Minister will start us off, and then we'll move to questions.
All right, well, good afternoon, and thank you for joining me here today. Today I'll be tabling Bill 14, the Justice Statutes Amendment Act in the legislature. First, I'd like to address that in recent months, we've seen recall legislation be irresponsibly misused and weaponized for political purposes rather than applied as intended. This has been a clear abusive process. We've been clear that the Recall Act should be used for ethical violations and breaches of public trust. However, Cabinet and our caucus discussed this further, and we're not planning any changes to the Recall Act at this time. Our government remains very confident in our record and will continue to advance the important issues entrusted to us by all Albertans, and we remain focused on this work. We will defend our record from special interest groups and left-wing activists any day of the week. Now, our government has been clear that we encourage all Albertans to participate directly in our democracy through voting in general elections and through avenues such as the citizen initiative proposals. Democracy thrives when people trust the process, and those processes are open and accessible to people. Bill 14 will deter long ballot protests from happening here in Alberta. In the recent federal by-election, which saw Pierre Poilievre elected, we saw over 200 people put their name on the ballot. Many had the same financial officer and the same group of electors signing the nomination papers. Former Chief Electoral Officer Jean-Pierre Kingsley has gone so far as to call this practice, quote, an abusive process, end quote. That's why Bill 14, if passed, will increase the number of signatures required for candidate nominations and prohibit electors from signing more than one candidate's papers. We are keeping space for people who are serious about being elected while deterring those who are not. Additionally, in order to further ensure that voters are not confused when they go to the polls, Bill 14 will help ensure that Albertans know which party they are voting for on the ballot. This comes, as we've seen, some attempting to mislead or confuse voters. To address this, Bill 14 clarifies and expands the restrictions on party names and limits new political parties from using similar names to those that have already been established. We also know that voting in elections is just one way to participate in our democracy. This year, we've seen multiple citizen-initiated petitions brought forward by Albertans. When a citizen submits a citizen initiative proposal, we want to ensure that process is free from delays, that it is transparent, and that the data collected is not misused. That's why we're proposing changes that, again, if passed, would protect the privacy of individuals with increased penalties for the misuse of information, and would strengthen identification and verification requirements to ensure transparency and accountability when someone signs a citizen initiative petition. These changes will ensure the process is permissive and will prevent unnecessary delays. All of these changes to elections legislation will allow for Albertans to participate in democracy in a greater way. Before I wrap up, I want to touch on a few critical pieces of Bill 14 intended to promote collaboration and shared priorities within Alberta's legal community. Proposed amendments to the Legal Professions Act would make reference to our new governance agreement with Legal Aid Alberta. We remain absolutely committed to ensuring that legal aid is available to Albertans who need it. The updated governance agreement from the summer sets clear renewal terms to keep legal aid service delivery stable. It's also why Bill 14 strengthens the government of the Alberta Law Foundation, the governance, of the Alberta Law Foundation, to ensure funds provide direct access to the affordable legal services that so many Albertans rely on. Finally, we're increasing court capacity by allowing experienced justices of the peace to apply for an additional 5-year term after their initial 10-year term expires. This will help ensure that fewer court sittings are canceled so that Albertans can access court services where and when they need them. There's a lot of content in this bill, but as I wrap up, I want to be clear. Our democracy is better off when Albertans from all walks of life with diverse voices participate. And as a government, we'll always ensure that our democracy is one of trust and openness. Thank you very much. We'll take questions.
Okay, we'll move to questions. Julia, go ahead.
Hi, Minister. Julia Wong, CBC National. I want to ask you about the political party names and the amendments being proposed. Are you that unconfident in the United Conservative Party brand that you want to get rid of any other party that has the word conservative in it?
Well, look, this is not a new concept. Let's be clear. We know that, put plainly, we believe that election ballots and party choices should be absolutely clear and transparent for all voters. The changes that we're proposing in Bill 14 will improve voter clarity, and it'll limit the ability for groups like the longest ballot protest to flood a ballot with either a scenario we saw recently with more than 200 candidates, but more importantly with 10 different parties with the same or similar name. Some folks out there want to confuse people into voting for them based on the name conservative, but this is not a partisan issue. Let me be clear about that. This was an existing provision in our democratic process legislation, and it has always empowered the CEO to take steps to prevent that from happening. There are people who will undoubtedly, based on what we've seen in the long ballot protests, try to take the goodwill and the hard work of political movements all across this province, and we think that's wrong and it's inappropriate to do so. It would be no different than a party coming forward and seeking to register a name, the Alberta Democrats, or the New Liberals, or the Greenest Party. This is not what we want for the landscape here in Alberta, and we think that that's appropriate. And on another note, look, this is not a concept that is unique to Alberta either. I think every jurisdiction has rules that prevent a party from being registered with the same or similar name as another.
This is more of a clarification question because I still have a follow-up. You know, you talk about you don't want people to be confused. You talk about people wanting to improve voter clarity. Do you not think Albertans are smart enough to differentiate your party from another party that has conservative in it?
Yeah, look, I think that if we're talking about improving clarity, we want to make sure that the people who are voting are casting their ballots for not only the party that they believe in, but the political ideology that they believe in as well. And most certainly, I think that if you have a scenario, as we've seen in other parts of the country and including here in Alberta, where protest groups are engaging in organized opportunities to create mass disruption and abusive process, as I mentioned earlier. This is just inappropriate, and I don't think that Alberta would be better for it if we didn't do anything about this. The existing legislation before any amendments in Bill 14 have provisions that require the CEO to make these assessments anyway. We're simply clarifying that and making sure that the existing political parties that exist in this province are protected. It's not a partisan issue. It applies to every single registered political movement in this province.
I apologize. My follow-up relates to the power that would be given to you to decide what petition goes forward if there are two similar or same-sounding petitions. We know obviously that there is the Forever Canadian petition, and there is the petition being put forward by the Alberta Prosperity Project calling for Alberta sovereignty. So with this power, would you kill the Forever Canadian petition, or would you kill the Alberta Prosperity petition?
Well, look, I'm not going to speculate too much on what petitions might come forward, but I will say that we intend for this process and always have intended for the process to be permissive in nature. That is to say that we want to encourage Albertans to put important issues before other Albertans, especially if they meet the requirements under the Act to do so. What I will say is that the purpose or the power, as you say, being able to review the type of petitions that come forward is to ensure that, ridiculous or frivolous petitions do not move forward. And I'll give you an example of that, a fun example nonetheless, but still an important one. Some will certainly remember the petition in November of 2000, which was suggesting to then have Canadian Alliance leader Stockwell Day's name be changed. That gathered thousands of signatures, but it's a waste of time. It's not something that we want to entertain. It'll cost Albertans millions of dollars. Most real policy questions are not a waste of time, and we certainly will we're creating the landscape to allow that to happen.
Matt, go ahead.
Getting back to Thomas Lukaszik's petition, how does all of this affect that, if at all?
It doesn't affect it at all. Approved petitions will have, the legislation will not impact any approved petitions. They will move through the process as they were intended to do. As you will recall, the Forever Canada petition was tabled by the Speaker of the Assembly this week, and it'll move forward as the legislation intended.
And relative to the Alberta Prosperity Project, their ongoing litigation, like we could get a ruling any time now. Why not wait till we get that and have that degree of certainty when you're pushing ahead with this?
Well, because we don't know when that ruling is going to come forward, and we've always said that the Act itself was intended to create a permissive environment for Albertans to bring forward their important issues. The reality is that if somebody is able to put a question forward and get the requisite number of signatures required and demonstrate interest in a particular issue being put forward to Albertans, we're saying here that we'd like that to go forward in the least restrictive way possible.
Go ahead.
Will Vassar with the Western Standard. What made it necessary to shift these powers in relation to the petitions to the ministry rather than kind of leaving in the hands of the chief electoral officer?
Yeah, most certainly. Look, we've heard from from Elections Alberta and the CEO, and we know that the intention was always meant to be that the CEO would manage the voting processes. It's not to tell people necessarily what they can and cannot ask. I don't think that it should be necessarily the responsibility of the CEO to refer these matters to court cases, for endless litigation and month-long delays. We think that moving it here will allow the process, well, I should say moving the power to the ministry and the amendments that are related to that particular issue will still allow a process to proceed while its constitutionality is being assessed by government. Certainly, the minister will retain the ability to refer questions to the court for additional clarification as well. But the process or the amendments that are being put forward here will clarify that a process will not be held up by the courts if it is referred for a question on constitutionality.
And my follow-up would be, for your efforts you're making to prevent long ballots, is this, would you say, preventative or proactive to avoid this happening in the future in response to the federal incident, or is this something you've seen in Alberta with provincial elections you're trying to avoid?
Well, we've seen it in the federal election and the federal by-election recently. We know that those that are experts in the field have commented on this. I think that it's very telling when the former CEO of Elections Canada calls the long ballot protests an abusive process. We've seen the presentations of these ballots, which are sometimes a meter or two long as well. And we think that this is a proactive step here in Alberta to preventing that type of protest from interfering with and creating administrative burdens here in Alberta.
We'll go to the phones next, and then back to the room for a few questions. Operator, can we get our first caller, please?
Don Braid, Calgary Herald.
Yes, Minister, you've got Thomas Lukaszik's petition. He suggested at the early part it was about a referendum, and now says he doesn't want a referendum. He wants you guys to take it into committee and then go to the legislature, perhaps a motion endorsing Canada and so forth. What is your choice? Are you going to refer, you could, I take it, send it to a referendum. Are you not going to do that? And what about the one that's now before the courts? Is this legislation, which parts of which are retroactive, going to take the separatist question out of the court and enable it?
Yeah, look, thank you for that, Mr. Braid. I will say this, the process that is outlined in the Act is clear. What happens with the Lukaszik petition is that it has been tabled in the legislature. It will be referred to a committee, a legislative committee, for review, and they have 90 days upon receiving that referral to make recommendations. I'm not sure I will presuppose what the will of the committee will be, but we'll wait and see, and certainly we'll adopt the recommendations from that committee. When it comes to the second part of your question, the legislation is also clear. The intention, again, is to make this a permissive environment for people who are seeking to have important matters put before Albertans. And what it says in Bill 14 is that the existing court litigation processes will be discontinued, and the petitioners of any other petition, including the Alberta Independence Movement, will be allowed to be resubmitted within 30 days. Now, we're going to be very clear about this, and I will say this: Albertans have expressed, I think, a concern with those seeking that independence be piggybacked on the work of the Forever Canadian petition, or Forever Canada petition, I should say. If those seeking independence believe that they have the support for it, this is their chance to prove it. This is their chance to demonstrate it. And we believe that they should earn the ability to put that question to Albertans by going through the rigors of the process described in the Act. That means collecting the requisite number of signatures and filing the appropriate paperwork and the fees to do so. By permitting it, again, to proceed, they'll have the opportunity to do the work without piggybacking off the hard work of a petition that is unrelated to it, I would say. So I hope that answers your question.
Do you have a follow-up, Don?
No, actually, that answers my question.
Yeah.
Okay, we'll go back to the room. Connor, go ahead.
How was the list of inappropriate words for party names decided on?
Yeah. Very simply, existing political parties that have been registered here in Alberta or exist here in Alberta in one capacity or another.
Is it, are you concerned that it may be seen as potentially trying to hinder what we know is a group that is attempting to restart the former progressive conservative branding?
No, I think that the amendments are a tribute to the respect and the hard work and the goodwill that have been built up by all political parties here in this province. Political parties, like any other entity, corporation, nonprofit, deserve to have their goodwill protected. And that is what we're seeking to achieve here. Again, if I point you to the list, you'll see a long list of names that have nothing to do with the Conservative Party. And I think it's important to keep in mind that the purpose of providing for the list was to recognize the goodwill of those existing political movements here in this province, many of which have existed for decades, some of which we don't hear much about, but nonetheless important for us to recognize the goodwill that they've established here in Alberta.
Okay, we can take one more question. Let's go to Catherine.
Sure, Catherine, all Alberta. So I'm hoping you can clarify, since you said this applies to all parties. The government officials said that the predecessors only apply to legacy parties that were the result of a merger. So are you saying any party that in a previous iteration of their name had one of these words, they could change their name and use it? Or is it just if the party was the result of a merger?
So I'm going to try to answer your question, and if I don't, you can ask again. If a party, for example, or two parties seek to merge, then there would be no issues with them using a one or a combination of the new names, so long as they both consent and agree to it. If a party in this province deregisters and no longer exists, then the CEO could certainly consider re-registering that particular name, because it isn't protected by the goodwill or the registration or the existence of either an existing or a legacy party. But if I think what you're asking is, when a legacy party merges into or forms a new party, is that previous name protected? And I would say yes, it is.
I'll maybe follow up. But again, I'm trying to understand where this justification on confusion comes. Because for multiple election cycles, there's been multiple Wild Rose parties. There's been multiple independence parties, including a Wild Rose Independence Party. So it just seems like the timing just so happens at the time the Progressive Conservative name is wanting to be used. So why was it not an issue to have multiple Wild Rose parties, but it is now that there's a progressive conservative?
It's always been an issue, and that's why the existing act contains a very specific provision that provides the CEO of Elections Alberta with direction on this, where a name is likely to cause confusion, as it reads in the existing act. The CEO should not allow a new party or a successor party to register where a legacy party doesn't approve of it. So I don't think that this is a marked move away from what was already existing. I think that the provisions have always been in place. What I am addressing here and what I intend to address here with this change is what we've seen developing all across Canada. Again, the protests that we've seen from people who have taken it upon themselves to create mass confusion and mass administrative burdens on the electoral process. It is not unlike what we've seen in the long ballot protests. 200 people who put their name on a ballot here in Alberta, with none of them, or the vast majority of them, receiving very little, if any, votes at all. The other thing that we're concerned about is a similar approach where you have 10 groups seeking to register a conservative or a socialist or a liberal party or something like that within the name. There is a balance that needs to be found between the work and the hard work and the goodwill of established political parties in this province and the ability to allow them to be recognized for that work and their political ideologies and positions without having protesters create mass confusion and mass burden for our elections.
Okay, that's all the time we have for today. Thank you. Oh,
What's that?
that's all the time we have, unless you want to take one more.
Take one more.
Okay.
From who?
Lisa or me?
Sorry.
You decide, Minister.
If you're the only two left, let's just go with you two. Yeah, we can do it.
pick both of you.
Yeah, Lisa, go first.
Okay, Lisa Johnson with the Canadian Press. This is the second time you've cleared away hurdles for people to bring citizen initiative referendums forward and made it easy for the separatist movement to also make those applications. Why not just call a referendum yourself instead of continuing to clear away these legal hurdles?
Well, look, what I think of a particular question or a particular petition is completely irrelevant to what this act and these amendments seek to achieve. The purpose of what we're doing here is intended to create a permissive environment, a simpler environment, a more streamlined one for individual Albertans who have important matters that they want to put forward to other Albertans to be able to do so. Whether I like the question or not, whether I agree with the question or not, is completely irrelevant. And so when you say that I'm clearing the way for all Albertans. I'm clearing the way for anybody from any political stripe or any ideology or any position to be able to put that question to Albertans. It is the purest and simplest form of direct democracy, and it has nothing to do with the separatists, as you say. It has everything to do with creating an environment that allows any Albertans to participate in democracy with the least restrictions possible.
Thank you. And I'm also wondering, so just technical clarifications here, because we couldn't get an answer from the officials this morning as to what happens if Justice Feasby releases a decision before this legislation passes. Does that throw out his decision? But I'm also wondering if this, by removing the requirement, did the Chief Electoral Officer not allow the same or similar proposals to go forward? Does that open the door for you to allow simultaneous questions on the subject of separating or not separating onto the same ballot? Is that a possibility in the future?
Look, I'll answer your first question before I go into the second one. But the idea here is that if we are going to move forward with this particular process, that we're always going to create again an opportunity for people to bring their important questions forward and do so without the hindrance of either the CEO or the government in doing so. We think it's important for them to be able to, or it's important for Albertans to be able to present questions to their fellow Albertans without the obstacles of that we've seen in other scenarios. When it comes to, again, the question you've had about, maybe I'll continue with the question about Justice Feasby and the court decision. The amendments will create, again, sort of a renewal, I guess, if you will. The approved petitions will continue to proceed as they were, and the petitions that have not been approved will have the petitioners will have the opportunity to refile within 30 days at no additional cost. That is independent, I would say, of whatever the court decides in this particular issue. And the reality is that the court's entitled to make a decision on any question put to it, independent of what we're doing here. So I expect that the court process may or may not continue. That is somewhat unrelated to what we're doing here. What we're saying here is that those that have not been approved or referred to the courts will be effectively reset, and the opportunity for the petitioners will arise to resubmit again and move forward under the new rules. Again, I think I'll make it again abundantly clear. The people here in Alberta, those that have worked on the Forever Canada petition, for example, those that have worked on independence petitions, have expressed their concern with one petition piggybacking over another. And we think that these rules will clarify that for everybody. There is no intention to allow one to piggyback over another. And what we've heard is conversations about whether or not the Forever Canada petition is effectively a question of independence and separation, because the no's to that will signal potentially the Albertans' desire to separate. So we think that if we allow the process to proceed in the Forever Canada petition as it is, that a different petition will have to go through the same rigors and get those signatures that they need.
So simultaneous, possibly yes.
Simultaneous, sure, but piggybacking, no. There will be no, combination or hybrid or that type of thing, if that's what you're asking.
All right, and last one.
So the UCP likes to portray itself as the party of free speech. And then now today you're saying that you want to restrict which words can appear in the name of a political party. How do you explain and justify this restriction on free speech and freedom of association, which is protected by the Charter?
Well, certainly, the same way that we protect businesses who have names from others taking those names and using them, using their goodwill and their reputations. We do the same thing all the time. There is no difference between somebody registering a political name that is very similar to an existing and well-established political party as there would be for a restaurant that has been in operation for decades, having a competitor open next door with a very similar same name. There are rules about this all across our province and our country. This is not unusual.
And with that bill, we're now at, I think, 5 or 6 court proceedings that this government is trying to stop by passing a bill in the legislature. Thinking about the trans bills, the notwithstanding clause, I'm talking about AIMCO, even the teachers trying to overturn the bill number 2. Is it becoming normal practice for the Alberta government to interfere in courts to try to stop any kind of legal proceedings? What about judicial independence? What about due process of the people who want to get their rights acknowledged?
Yeah, the short answer is no. It's not becoming common practice. I think that we have a tremendous amount of degree of respect for the courts and their independence to issue decisions and to operate wholly independent of the executive or legislative branches of government. But there are important questions that need clarification, and there are important issues that are arising here in this province that Albertans expect their government to respond to. And a lot of those are some of the ones that you mentioned. And this is another opportunity for us to create a clear and an open and transparent environment for Albertans. There is very little, I think, in the way of linking interference in the courts with trying to protect political names and political reputations in this province. I don't see the connection. I think that political parties deserve the recognition of the work that they've earned. I believe that Albertans deserve to know the political ideologies and positions of the political parties that they support. And I certainly want to make it abundantly clear that the purpose of this is to prevent disruption and protests like we've seen in other parts of the country. We just don't have any space or desire to see that here infiltrate in Alberta, and we'll stand by that. Thank you.
Thank you, everyone.